The pre-trial conference, which is when the court agrees with the advocates as to how the petition will be processed in terms of the timelines that are needed for prosecuting various applications. But even before the proceedings began formally, the petitioner's lawyers indicated that they have instructions to withdraw the petition. Now the law requires that that sort of withdrawal is done through a formal application. And it is also advertised in the newspapers, and so they have been given 7 days to do that, and then we'll be back here on the 24th of this month for the prosecution of that application. For us, speaking on behalf of the third and fourth respondents, the governor and the deputy, I think we appreciate the step taken. I think this county needs to move forward without the necessity of spending a lot of energy in court. There's a lot of work to be done, and I think people should not be distracted through court proceedings like happened in the last time. So we're grateful, and we're happy that that has happened, and we're looking forward to actually the prosecution of the application and for us to file that matter aside and move on with other more important issues. 21, which allows parties to withdraw from a petition they have filed, but they are required to file formally a formal application. So the election petition regulations, rule number 21. So they will now be proceeding to do that, and then the matter should be concluded without. We are lawyers, so I can only say we only work on the basis of what is disclosed in court. So as far as we are concerned, what we know is what was disclosed in court. Yes.
I'm an advocate for the petitioner in this matter, Honorable Wangui Ngirici, the first petitioner. And today we came to this court for pre-trial so that we can take directions on the hearing of the petition. But we have informed the court that we'll be making an application to withdraw the petition in accordance with the instructions given to us by our client, the Honorable Wangui Ngirici. So within the provisions of Rule 21 of the election rules, once a petition is filed, it cannot be withdrawn without leave of the court. So you first seek to get leave of the court before you are allowed to withdraw a petition. So the court has given us time to file that application, 7 days, to file the application and serve upon the respondents. Then the respondents will respond to the application, and we come back to court on the 24th of this month so that we can take directions on the hearing of the application. So ultimately, after the hearing of the application, the court will make a decision to make a ruling whether to allow the application for withdrawal of the petition or not. If the court allows that, then we shall withdraw the petition. But if the court does not allow, then it means that we shall proceed with the petition to the full hearing. Those are the reasons why the law provides that before an application, the court makes a decision, the respondents will be allowed to file responses, and their responses, they will argue on the issue of costs. We will respond to the issue of costs, and the court will make a decision on who is supposed to get the costs, and if so, how much, or if not, then the matter will be taken to the deputy registrar for assessment of the cost. So that one will come much later in the application.